Good day, everybody. Thank you for joining us for class today. For the benefit of anyone joining us for the first time, my name is Aleem Khan. I'm the editor of the news company of Trinidad and Tobago, or news.co.tt, which is also our website address. So you can find us at www.news.co.tt, so you can also follow us on Twitter and Instagram to stay in touch. Our handle is at www.newscott, or you can WhatsApp me on 1-868-798-1108. Stay in touch with us and reach out to me anytime. I will be happy to answer your questions. Today we're starting a new semester. You can get the names of the texts that would help you with this course in the description, but just for your convenience, again, they are Gatley on Libel and Slander, and Clark and Lindsell, chapter 22, which is the chapter on defamation. Those are the main books, the main text, but we will also be looking at every Privy Council judgment on libel and slander that we can get our hands on, including the most recent ones as they come out. You will also be required to read the Civil Proceedings Rules of 1998. Today we're going to jump straight into the first text, that would be Clark and Lindsell. I'll be reading from my copy, but if you have a copy that's later than mine and there are updates, please do bring that to our attention in the comments. Okay. In any event, the Privy Council judgments, which we will be looking at as they come out, as well as the ones, the standing ones, the ones that have already come out, those will provide us with the very latest jurisprudence available. So we begin today with Clark and Lindsell, and as we move through it, we will be pausing to take notes, make comments, and take questions if you have any. Okay, so let us go to that now. And I do have to just play the intro, and we will be going straight into the text immediately after.
Page 1, Page 1. Clerk and Lindsell on towards 20th ed. Main volume. Chapter 22, Defamation. Section 1. Generally. Action of defamation. 22-01. The law recognizes the right of every person, during life one to possession of a good name. A person who communicates to a third party matter which is untrue and likely in the course of things substantially to damage the reputation of a third person is, on the face of it, guilty of a legal wrong for which the remedy is a claim in tort for defamation. Point 2 Defamation is therefore the tort which protects reputation, and the courts have, on more than one occasion, stressed that defamation is the only appropriate action for the vindication of reputation. Point 3 There are, however, instances of other causes of action which may seem to overlap with defamation. In Lonro v. Fade, number 5, for the Court of Appeal held that, although the claimants would have to sue in defamation in order to claim damages for injury to reputation or feelings, defamatory statements made by the defendants, causing pecuniary loss, for example, loss of orders or loss of trade, could give rise to an action in tort for conspiracy at the suit of Lonro. The Court of Appeal observed, however, that to allow recovery of damages for loss of reputation in the tort of conspiracy would enable the claimants to circumvent the requirements of defamation, for example the defenses of justification or fair comment. Point 5 In Malik v. BCCI 6 the House of Lords held that an employee could in principle recover damages for the financial loss stemming from stigma and loss of reputation caused by the employer's breach of the implied obligation not to act in a way likely to destroy or seriously damage the trust between employer and employee. Also in Spring v. Guardian Assurance 7 the House of Lords granted a remedy to the claimant who sued his former employer for negligence in writing a derogatory reference.
Okay, we're going to slow down a little bit and then resume.
Give rise to an action in tort for conspiracy at the suit of Lonro. The Court of Appeal observed, however, that to claim damages for injury to reputation or feelings, defamatory statements made by the defendants, causing pecuniary loss, for example, loss of orders or loss of trade, could give rise to an action in tort for conspiracy at the suit of Lonro. The Court of Appeal observed, however, that to allow recovery of damages for loss of reputation in the tort of conspiracy would enable the claimants to circumvent the requirements of defamation, for example the defenses of justification or fair comment. Point 5 In Malik v. BCCI 6 the House of Lords held that an employee could in principle recover damages for the financial loss stemming from stigma and loss of reputation caused by the employer's breach of the implied obligation not to act in a way likely to destroy or seriously damage the trust between employer and employee. Also in Spring v. Guardian Assurance 7 the House of Lords granted a remedy to the claimant who sued his former employer for negligence in writing a derogatory reference in relation to him, though an action for libel would not have lain since the occasion was one of qualified privilege and malice could not be shown.
Okay, so this is the first paragraph of that chapter 22 on defamation. We have much more to go, and there are also many footnotes. Okay, so ideally we should read everything. All right, but this summary, this first paragraph, which gives you an overview generally, we can pause on that for now. Well, we'll be getting into the more substantive issues and matters and defenses later on. But let's just finish these footnotes. These two are important, the first two, and then we will resume from there.
Shown. 1. An action is not maintainable for defamation of a deceased person, Broom v. Ritchie, 1904, 6F 942. This is left unchanged by the Law Reform, Miscellaneous Provisions, Act 1934 S.1, 1, and see the report of the Committee on the Law of Defamation, CMND.7536, paras 27-29. The Neal Committee recommended that this should not be changed so as to allow an action to be begun or continued after the death of either party. An action for slander of title causing damage to the deceased's estate survives to the personal representatives, Hatchard v. Meg, 1887, 18 QBD 771. and C. Zelic, 119 NLJ 769. 2. There is, nominally at least, a law of criminal libel which differs from the tort in several respects, notably that justification is not a defense. C. Gatley, Law of Libel and Slander, 11th ed., 2008, ch. 24. Also see Goldsmith v. Sparings 1977 1 WLR 478. The Neal Committee recommended that Parliament should consider whether the public interest is served by the retention of criminal libel, but it has been retained. However, prosecutions are very rare.
Jurisdiction 22-02. The issue of jurisdiction in defamation has become increasingly relevant, in a European context and in relation to international publications, especially in the light of increased means of communication. English libel laws attract litigation from claimants who may be unable to sue in other jurisdictions, e.g. the USA, in respect of material published in international newspapers and journals and on the Internet.
Okay. Okay. So this is very important. This piece is very important. This piece is very important because well, it's important for us because we are an internet publication, but it's also important for everyone to take note. Okay. So let's
Internet. Point 9. 8c. For example, Cheville v. Presse Alliance SA 1995 2 AC 18. 9c, e.g. Berezovsky v. Michaels 2001 WLR 1004, Multigroup Bulgaria Ltd v. Oxford Analytica 2001 EMLR 28 and King v. Lewis 2004 EWCA Civ 1329, 2005 EMLR 4. The issue arises within the United Kingdom in a modified form. See Lennon v. Scottish Daily Record and Sunday Mail 2004 EWHC 359, QB, 2004 EMLR 18. Specific problems arise where a publication is circulated in several different jurisdictions and the English courts must decide issues under the English law of defamation. Defamation. See Lukoyak v. Unidad Editorial SA 2001 EMLR 46. Page 4. Reforms. 22-04. On more than one occasion, English judges have criticized the complexities and absurdities of the tort of defamation, and several attempts have been made to rationalize and simplify it. Point 15. In 1991, the report of the Supreme Court Practice Committee under the chairmanship of Neil J. recommended a number of changes in procedure and practice in defamation actions. In 1994, new rules of the Supreme Court were introduced to put some of these reforms into effect. The new rules also provided for a procedure involving the assessment of damages by the judge alone where there was an innocent defamation. The Defamation Act 1996 has introduced a number of reforms in the law of defamation which give effect to the recommendations of the Neal Committee's report, the proposals of Lord Hoffman and the Lord Chancellor's consultation paper on the defense of innocent dissemination, 1990. The Civil Justice Review conducted by Lord Wolfe in 1997 looked in a radical new way at the whole administration of civil justice. Since defamation is so closely affected by procedural complexities, the Wolfe reforms, under the Civil Procedure Rules 1998, provide radical and important changes, when coupled with the provisions of the Defamation Act 1996 and the rules putting its provisions into effect, see below. These were intended to be particularly important in reducing procedural delays and complexities in defamation proceedings. The Human Rights Act 1998 gave effect in the courts of the United Kingdom to rights and freedoms guaranteed under the European Convention on Human Rights. Its impact on defamation is growing, with issues being regularly raised in defamation litigation under Arts 6, 8, and 10, see Paras 22 to 10 ETSEQ. In March 2011 the government published the Defamation Bill 2010, which is intended to fulfill the government's election manifesto pledge to review and reform libel laws to protect freedom of speech, reduce costs, and discourage libel tourism. The main features of the bill are as follows. There is a reversal of the presumption in favor of trial by jury, by virtue of S.69, 1, of the Supreme Court's Act 1981. The presumption now works the other way, so that trial by jury must be justified in accordance with a series of criteria including that such a trial would be in the public interest or the interests of justice. 2. A codified defense of responsible journalism on matters of public interest, which adopts the law as set out in Reynolds v. Times Newspapers Ltd 2001 2 AC 127. The provision alters the factors set out by Lord Nichols so as to seek to make the defense more straightforward for the media to apply. The proposed defense does not require the court to consider the nature or status of the information published, whether it contains the gist of the claimant's side of the story, or the tone of the publication. It does however require that compliance with any relevant code, e.g. the Press Complaints Commission Code, should be taken into account, although the PCC Code does not currently contain any detailed provisions concerning responsible journalism. 3. A defense of truth, replacing the common law defense of justification. The defense succeeds if the defendant can show that the allegations are true or substantially true in either the meaning contended for by the claimant or a less serious meaning that the words are found to bear. Where a publication contains more than one meaning or allegation, the defense does not fail if any meaning or allegation not shown to be true does not materially injure the claimant's reputation having regard to the truth of the remaining allegations. This simplifies the common law defense, and includes the partial justification provision under S.5 of the Defamation Act 1952. Page 5. 4. A defense of honest opinion, replacing the common law defense of fair comment or honest comment. This is intended to simplify the law of comment, and again make it more straightforward. The defense would succeed if there were one or more facts or otherwise privileged material on which an honest person could hold the opinion expressed. There is no concept of malice defeating a defense of honest opinion, although the defense fails if it is shown that the maker did not in fact hold the opinion expressed. Wider scope is given to report-based absolute and qualified privilege, extending the ambit of absolute privilege to reports of court proceedings around the world, whereas it was previously limited to reports of UK courts, the European Court of Justice, the European Court of Human Rights and international tribunals set up by the Security Council of the United Nations. Qualified privilege is also extended to summaries in addition to copies or extracts of material produced by a range of bodies which includes more international bodies or organizations. 6. The multiple publication, or Duke of Brunswick, rule is abolished, which entitled a claimant to bring an action more than 1 year after the original publication where the publication had been repeated. Duke of Brunswick v. Harmer, 1849, 14 QB 185. The single publication rule will apply to repeat publication of the same material by the same publisher, and prevent such an action being brought after the limitation period has expired in respect of the original publication, the limitation period being 1 year. This will mean that it will not be possible to bring an action over archive internet articles which are deemed under the Duke of Brunswick rule to be republished every day that they are accessible online. Online. 7. There are new provisions aimed at dealing with libel tourism, which require that an action against a person not domiciled in the UK or another member state. 7. There are new provisions. 6. The multiple publication, or Duke of Brunswick, rule is abolished, which entitled a claimant to bring an action more than 1 year after the original publication where the publication had been repeated.
Okay. We're paying special attention to this paragraph. All right, the multiple publication. and also to a defense of honest opinion. Okay, so all these defenses are valid. All right.
Repeated, Duke of Brunswick v. Harmer, 1849, 14 QB 185. The single publication rule will apply to repeat publication of the same material by the same publisher, and prevent such an action being brought after the limitation period has expired in respect of the original publication, the limitation period being 1 year. This will mean that it will not be possible to bring an action over archive Internet articles which are deemed under the Duke of Brunswick rule to be republished every day that they are accessible online.
Okay, we're going to take note of this paragraph. The multiple publication rule is abolished. Okay, this means that it is not possible to bring an action over archive internet articles which are deemed under the Duke of Brunswick rule to be republished every day that they are accessible online. So this rule is abolished. Okay, let's take a note of that.
Online. 7. There are new provisions aimed at dealing with libel tourism, which require that an action against a person not domiciled in the UK or another member state of the EU should not be brought unless the court is satisfied that, of all the places where the statement complained of has been published, England and Wales is clearly the most appropriate forum for the action. The provision does not deal with the perceived problem of foreign claimants forum shopping and suing in England and Wales, and does not deal with European-based claimants or defendants, since to do so would fall foul of the Brussels and Lugano Conventions and the Cheville case, Cheville v. Press Alliance SA, C68/93, 1995-AC18. A further provision prevents an action being brought in England and Wales where there are multiple publications around the world, unless the harm caused in the jurisdiction can be characterized as substantial harm to the claimant's reputation having regard to the extent of publication elsewhere. 8. Further provisions deal with secondary responsibility, making it more difficult to bring actions against Internet service providers or the broadcasters of live programs, bodies corporate suing. They are required to demonstrate that they are likely to suffer substantial financial loss as a result of the publication, and a threshold requirement for defamation claims proposing that an action for defamation must be struck out unless the publication has caused or is likely to cause substantial harm to the claimant's reputation. The bill, which is currently at committee stage in the House of Lords, as of July 2011, has been much criticized as not actually fulfilling the government's aims. It is anticipated that it will be amended significantly before being passed into law. Further committees are reviewing the rules on civil litigation costs and the costs in publication cases, and it is anticipated that new rules of court will be enacted to bring to an end or page 6. Significantly limit the conditional fee, or no-win no-fee, costs regime, which currently allows for successful litigants to claim success fee uplifts of up to 100% of the costs claimed. The European Court of Human Rights has ruled that such success fees are a disproportionate interference with the right to freedom of expression, MGN Ltd v United Kingdom, APNO 39401/04, 2011, 53 EHRR 5. 15 e.g. May LJ in Morel v International Publishing Co. 1989 3 All ER 733 at 734 to 735. See also the observations of Stuart Smith LJ in Williams v Mirror Group Newspapers, The Independent, February 12, 1991, CA and Neil LJ in Reacham International Ltd v Express Newspapers plc, The Times, June 19, 1992, CA.
Okay, as you can see, this is indeed a very uh, it's a very um, time-consuming uh, time-consuming exercise. So we will pause there for now, and we will resume tomorrow. So see you then. Study hard, and until next time. Okay. Enjoy the rest of your day or night, depending on where in the world you're looking at us from. Take care. Bye bye.